Welcome to The Smart Divorce on Divorce Source Radio, helping you move forward with focus, hope, and confidence, saving you time, money, and your sanity as you build a better life post-divorce. I'm Steve Peck. Deborah Moskovitch, divorce consultant, educator, and author of The Smart Divorce, brings you the leading experts and researchers in the divorce arena. We'll also be speaking with those in the trenches, people who've learned from their divorce and how their experience has changed their lives. And they would tell you for the better. Deborah's learned that divorce can be a beginning, even if it looks like an end. Divorce can be rich in opportunity to learn and grow from. And we're going to explore how to take this information and create a positive post-divorce life. And now, here's Deborah.
How are you today? I've got another great show.
Oh, I'm good. Mark Baer is back today. Great.
I know. I can guarantee it's going to be a great show because we spoke with Mark before. We talked about finding a lawyer who's a problem solver and not a conflict creator. And guess what kind of lawyer Mark is? He's
a problem solver.
Absolutely. So today we're going to talk about lots of different things. I want to look at mediation. I want to talk about whatever thoughts that Mark thinks the public needs to hear about.
Well, Mark, it's good to see you again, this time on Skype. The last time we met was in Detroit, but welcome back to DSR.
Thank you. Thank you so much for having me back. I always enjoy being on your show. And the Smart Divorce Show at that with Deborah. Deborah, talk to us. What are you interested in today?
Well, yesterday I presented a little topic on what I do as a divorce consultant and educator and all about the Smart Divorce Resource Toolkit to a group of mediators. And you know what? I learned a lot about mediation. I'm embarrassed to say that I didn't already know. I learned that there are two different models, and this is what I'd like to explore with you, Mark, the directive versus the evaluative model of mediation. Like, what does the public need to understand about different forms of mediation? I just thought that you go into a mediator and in Canada we have open versus closed mediation. In the U.S., the terms are different. I don't recall offhand. But in terms of whether or not a report is filled out in case that there's a breakdown in mediation and go to court, what does the public really need to understand about mediation?
You know, there's been a lot written about mediation, and there's a person by the name of Joan Kelly who's done a lot of research on mediation, and she's found that there are so many models of mediation that if you're trying to figure out what is common between the mediation models, the only thing that any of them have in common is that there's at least one neutral in each mediation model. There are far more differences between the models than similarities. And so the problem is that what the wife might understand to be mediation may be different than what the husband understands to be mediation, might be different than what the mediator who they select defines as mediation. So I think it's important that everybody understand what it is that they think mediation means to them so that they do the right kind of mediation, or at least what they're intending to do.
But I thought, like mediation, you go into a mediation, a neutral third party, and the couples arrive at a decision together. Like, what's the difference? Like, why does everyone have, or what are all the different perspectives on mediation? That's what I don't understand then.
Yeah, well, the thing that's frustrating for me is one model, for example, is evaluative, which you had mentioned. And in evaluative mediation, what it really is it's like what a settlement conference would be, where you have a retired judge or commissioner or attorney who is basically evaluating the positions, rights, and obligations of the parties. They basically have their little crystal ball, and they're taking the crystal ball and they're saying, if you take this thing in front of the judge, this is what the result is going to be. And the problem is that while that might work to some degree in a type of law where you have liability, like, for instance, a car accident case, and there's questions as far as who caused the accident, for example, or a property boundary dispute, or something of that nature where it's objective, it might work. But when you're talking about family law, it's subjective. Where is the liability? They got rid of fault-based divorce in every state in the U.S. and many other places at this point. If there's no fault, then what is it that they're evaluating? Because when I understand that there's laws in place, but the laws can be applied differently depending upon credibility findings that somebody makes, for instance, the judge, or findings of fact, because once you figure out husband and wife, for example, they're not going to be in agreement on what the facts are. So the trier of fact, the judge, or the evaluative mediator are going to be determining what the facts are. Well, if everybody comes from their own life experiences and backgrounds, then everybody, whether we want to admit it or not, has our own values, biases, opinions, and assumptions. So when the evaluative mediator is taking their crystal ball and saying, this is what's going to happen if you go to court, so why not just resolve this thing now? They're using a crystal ball. And the problem is that if the judge has different life experiences and backgrounds than the evaluative mediator, then the judge is very likely going to come up with a different credibility findings, factual findings, and that's going to result in the application of law being applied differently. So it's real problematic. And if one of the things about the benefits of mediation is that it doesn't create winners and losers, well, court creates winners and losers. If you're doing evaluative mediation, you are creating winners and losers. You're just getting it by agreement on who the winner and loser is, because you're saying if you go to court, the court's going to say that this is who the winner and loser is. So just agree now that this is the winner and loser.
So that's a bit of an arm twisting. It's not really an agreement. It's a forced agreement then.
Right. Yeah.
It's keeping you out of court. But that's really interesting, because when you go to court, what you're fighting for are your rights, right? In terms of what the Divorce Act says. At least that's what it's called in Canada, the Divorce Act. I don't know what it's called in the U.S., but, here is everything is set out in terms of how matrimonial assets are to be divided, how child support is to be allocated, that type of thing. So that's very much based on rights. But then there's another way to look at it, which I think should be part of a mediation. And I think that might be part of directive mediation, where it's based on needs. Like if you have a special needs child, for instance, perhaps the child support needs to be more, because you're going to have far more expenses than what's set out in the child support guidelines, right? Like you're going to have more expenses because of the needs of the child.
I agree, and I think that those type of things can be considered as a hardship anyway in guideline child support. So even if we're using a program, if the child has special needs, I think that there's the ability for the judicial officer or whoever to factor that in. So, my issue with guideline child support is a bit different than does the child have special needs or not, because I think that can be dealt with through guideline child support.
Yeah, so maybe I picked a bad example in terms of special needs, but, you could have a child who's plays tennis or plays hockey and is just like incredible at the game and just absolutely loves it and it has a passion for it, but it's very expensive. I guess it's seen as an extraordinary expense, or in Canada we have it at Section 7. So those kinds of things. But I think that like based on needs and lifestyle, like what you had is when you were married, I guess that's what's very different in the evaluative model, because it doesn't take into consideration certain things, which might exacerbate the battle.
Well, I think I think that in the evaluative sense, at least here, we're going to be using DisoMaster, which is the computer program that calculates guideline child support. And The problem with that is that it is in essence trying to find a one-size-fits-all result, because assuming that if you have a situation where husband and wife each have a certain percentage of time with the children, and they each make a certain amount of money, and they each have certain tax deductions, for example, and deductions on their paychecks. These things get calculated into the DISO master program, and it comes up with guideline child support, and that's going to be the same no matter who uses the program, as long as you all have the same version, because they change it every year, because it changes with tax changes, for example. But the reality is it's going to differ depending upon what information you plug in and what categories that you plug them into on the program. But let's say, for example, that you have two families that have exactly the same information, same timeshare, same income for each spouse, same deductions, same everything. And we're using guideline child support. Well, the expenses of the let's say the parent who's receiving child support, the expenses that parent has for the children may not be the same in both cases. For example, maybe that parent is living in a less expensive area where they have 3 children and 2 of them are of the same gender and they're sharing one room, and the other one is a different gender and has another room, but it's a small room, an even smaller room, and all the rooms in that house are relatively speaking small. And then you have the other scenario, which is the exact same amount of guideline child support, because it only takes into account the income, the gross income, the deductions from payroll, the timeshare, and the tax deductions. It doesn't take into account real expenses. So the other person lives in a larger place, which has bigger rooms for everybody, and each of the kids has their own separate bedroom. In that example, the amount of money that's being spent by that parent on the children is higher just for living expenses alone than the other example, but yet they're making the same amount, they're receiving the same amount of child support. Now, how fair is that? Because if the child support number in the example where they have a separate room for each of the kids and it's bigger space, actually, let's pretend that actually does amount to the expenses of the children. So they get a certain amount of child support, and the amount of money that they're paying for rent or for their mortgage or for whatever, that's proportionate to the additional space that they need for these 3 kids, and the bigger car, and the gas, and the utilities, and the food, and the clothing, and all these other things. They've done a budget, and the budget comes up that it's approximately equal to the guideline child support. It's not going to be true for the other couple, the other family that I gave you. So if the other family is spending, if the parent receiving the support is spending a lot less money on the kids than the support that she's receiving or he's receiving, then isn't, in essence, that parent getting a windfall? The money's not being used for the children. So isn't it some sort of spousal support or something that's a windfall to that parent, because it's certainly not being spent on the children in that example. And the problem is that if I have, for example, a situation where the guideline child support says that it's $7,000 a month for 3 children, and we sat down even with an accountant, and we figured out what the expenses were, everything, proportionate share of the utilities and housing cost and everything that's being spent on the children. And we find that it's costing that mother or that parent $4,000 a month in actual expenses relating to the children, but they're receiving $7,000. Well, the question is, what is the extra $3,000? The extra $3,000 a month is a windfall because that's what the guideline, one size fits all thing, says they get. And as far as I can tell, the attorneys are running and doing evaluative and saying, this is what DissoMaster says, so therefore I'm going to get this for my client. And their client says, yeah, I want this because I can get $7,000 a month. I'm going to get $7,000 a month. It doesn't matter that I only have to spend $4,000 to get the children, to take care of the children. I'm getting the $7,000 that the law says I can have. Well, I think there's good reason, if you want to think about it, for why the research seems to indicate that in intact families, parents who can afford to pay some or all of their children's college tuition when they get to be of college age, 90% of those parents pay. If they can afford, they pay some or all depending upon what they can afford. Change that percentage to 30% when you're talking about non-intact families, from 90 to 30. And we're talking of the parents that can afford to pay it. And the problem is, if you have a one-size-fits-all situation where we're not looking at what it's actually costing to raise the children, but we're looking at what a one-size-fits-all program says should be paid, then the paying parent thinks, and they could be wrong, they think that the receiving parent is getting a windfall. So they resent that. And if the parent is getting a windfall, then they're validated, but they may never know that. But like, for example, in the example that I gave you, if you have $7,000 of guideline child support, and you know that only $4,000 is what it's costing to raise the children, and you're entitled to get the $7,000, since it's supposed to be for the children, wouldn't it make sense to be more creative with that additional $3,000, from the 4 to the 7, and say, for example, that's my money. I could get that if I went to court. Why don't we, if I agree to put that $3,000 every month into a fund for the children's college education, paying parent, would you do the same? Would you put an equal amount? Because that $3,000 is mine. I could go to court and get it. So therefore, if I'm not taking it, and instead I put it for the benefit of the children for college, will you come up with an equal amount? And now we can have $6,000, for example, going into a college trust fund for the kids. And the parent who's receiving child support is receiving exactly what they need. This kind of stuff's not being done because it's a one-size-fits-all evaluative thing.
Okay, Mark, you've got to do this because I think it is a fabulous idea. Because all too often, and I've read some arguments from parents who are divorced saying that they don't feel they should have any responsibility to pay for their child's post-secondary education. Personally, I'll give you like my personal bias. I do pay for my children's education because it's so important. And I pay for it 100%. So you can see that there's a different philosophy between myself and my co-parent. And I personally, I love your idea because it helps the kids out. If kids, just me, this is, my thoughts. My kids are working so hard at school. They're studying 24/7. They are in the library. Like my daughter is in the library all the time. I didn't speak to her for 2 weeks while she was writing exams because she was constantly in the library. So there's no time for her to work. So if you want to help your kids, if you can afford to help your kids, you should. Just because a parent feels. So, Steve, I know I can see in your face you have a different perspective.
I've heard kids say that, I have no time to work. Well, the reality is I know kids. My son was taken care of at college, but there were friends of his that weren't, and they were paying their own way. They worked in the summer, and they did it themselves. I think there's something to be said for kids pitching in.
Oh, I agree with working in the summer. I'm just wondering, when you've got a heavy, but that's just a whole other thing. And I think it depends on the kids and what their abilities are. But and that's a whole other discussion. But I think that Mark's comment is, if a parent is, and I don't want to use the word overpaid, but not using all the money that's provided towards child support. I love the idea of putting it towards college education, just and have fun. Now, we have in Canada an RESP, registered education savings plan. And then the government tops that up too. So if you had something that started saving for the kids to go to university, because statistics, and I know Joan Kelly very well. As a matter of fact, Steve and I interviewed her. I called her the rock star of divorce. I mean, she just knows so much. I've had a lot of conversations with Dr. Kelly because she's helped me out immensely on my research. But, we do know that children of divorce, the propensity for them to go to university is not as high as children in intact families, and budget is for sure like a reason. And in Canada, like to go away to Canada, the rates for education, the education to go to university is about $6,000, say on average for a bachelor's. I think in the U.S. it's far more. So like that's a big chunk of change. So if you can start saving, when you're divorced, based on putting a little bit away from your child support, I think that's a great idea. And having the parent that can afford it, the parent that's probably paying the child support, a little bit extra towards that, taking their obligations a little bit more seriously, I think is a fabulous idea.
Thank you. Before I say anything, wasn't there recently a strike of the students in Canada because of a tuition hike or something that I read?
Yes, there was. That was in Quebec. And as a matter of fact, and that was in Montreal. The kids there, the tuition there is even cheaper. It's less expensive than it is in the rest of Canada. And they were looking for an additional $300 a year over 5 years. And I think even with that increase, their tuition would still be less than what we pay here in Ontario. So that's a bit of a sore spot.
But what I was going to say is that it's just a question of how people perceive things. The reality, as I see it, is that these attorneys seem to think that they get a win for their client because they get the full $7,000 of child support they get the full $7,000 of child support that they can get for their client. But they don't take into account the fact that this is for every action, there's a reaction. And there's going to be a consequence for this. And the consequence seems to be, among other things, that this is going to impact who pays what, if anything, for the children's college education after this is all said and done. And these people can even say to their client, well, if you think I'm getting you more than you need, you can stick the additional amount into a fund. But what they're not taking into account is they're not getting the other parent on board. If they had an agreement that I'm sticking X amount of money into this fund, you stick an equal amount in, now we're getting the money to go in there. We're getting double the amount. So they're just not, these people are just not recognizing that there's a consequence to their actions, and the consequence is impacting the children ultimately, their ability to go to school, who's paying, how the children then react to the various parents depending upon who pays what, if anything. And they could have both contributed something by doing something creative like this.
You are touching on all my sensitive points here. Because the other thing is just in terms of child support. Now, I'm not exactly sure how this works, and that's why we've got you as a lawyer to give us all the insight and the scoop in terms of how long a parent is responsible for child support. Is it till they're 18 years old, age of majority? Are parents responsible through university, post-secondary? I mean, for me, I like, my bias is to help my kids as long as I can through their university years, be it an undergrad or postgrad degree. I want to help give my kids whatever it is that they need so that when they graduate, they don't have that stress of like a ton of debt. I mean, and I'm lucky that I'm in that position that I can do so. But there are parents that are in positions to do so that in a way, want to punish the other parent and stop paying child support as soon as a child graduates from high school.
Oh, Mark, your dad played some of those games with you too, didn't he?
Yeah, we talked about that before.
Yeah.
I think, well, it's true that they feel that they're, well, I can't get into anybody's head, so I wouldn't know for sure what they're thinking or what their reasons are. I would only know what they say. And that's not necessarily why they're doing it for real. But the reality is whether they're doing it to punish the other parent or whether they're doing it to punish the child somehow because maybe subconsciously it's bothering that parent because this child reminds them of this relationship that failed, and therefore they're punishing this child of that relationship, or whether it's the fact that they were paying guideline child support that they felt. And again, I've written an article, one of the first articles that I wrote that got published outside of the Psychological Association was on child support. And it was talking about the fact that it costs more to raise the children than people seem to realize because they're not factoring in the additional space that's needed in the houses or apartments, the additional utility expenses, the fact that they need bigger vehicles, they maybe use more gas, and all of these other intangible things. And so they think that there's a windfall when there's not, or the windfall that they think the other parent is receiving is certainly smaller than they believe. But if you're doing it on just the computer says X, without sitting down at the table and coming up with what the actual costs are, you're creating speculation as far as what that money is being used for, how much of it really is being spent on the kids. And they don't have to do an accounting for how it's being spent. And I'm not suggesting that they do need to do an accounting to the court, but you're creating a speculation in the parent who's paying that it's being misappropriated. And oftentimes it is, in the sense that the parent who's receiving doesn't have to keep an accounting of how they've spent it. They just get it, and they spend whatever they're spending on the children. And if they happen to spend more, then that's coming out of their spousal support or other assets. And if they're spending less, then they're just saving the money, and they may or may not realize. But it's not creating goodwill, and it's not creating the incentive to take care of the kids afterwards. And if there is a windfall and the parent receiving it doesn't make a deliberate point to set it aside for the education later of the children, it's going to be gone and it won't be there.
Would that be a responsibility of the mediator to help focus the parents in terms of this child support or spousal support or whatever the monies are, in terms of, okay, this is your pool of funds. You need to plan for the future, because you don't want to be sitting here in 5 or 10 years from now, and you know, things change. So, I really like the way that we're thinking here. It's just so different. How do you help couples then think, separated couples, co-parents, think about the needs of the child or their children, 5 or 10 years down the line? When I separated, my kids were 1, 3, and 7. So I had 2 that weren't even in elementary school. So why would I even think about university? And it did become an issue, obviously, years down the line, but not everyone's high conflict. Most are not. So how do you help couples rethink or co-parents rethink their finances in terms of the long-term best interests of their children, in terms of the education?
I think it's much, you're touching upon something that's not, I can't answer that question other than to say that it's going to vary from person to person. I was just at a convention for California Collaborative, CPCal, a couple of weeks ago. And I went to a lecture that was given by Pauline Tesler, who I think is wonderful and has done amazing research.
I interviewed her for the Smart Divorce.
Okay, well, you get wonderful. I feel honored that I've been interviewed by you now the second time because you're wonderful people on your show. I know.
And no, that was my book. I interviewed her for my book. Yeah. Okay, go ahead.
So anyway, but she found some really interesting information. There seems to be a biological connection between money and what it represents and how we behave. There's been research. I think it could be found on these videos could be found on YouTube, I believe. But they, for instance, had two groups of people. One group was counting just plain paper, and another group was counting currency. But they weren't counting how much the money added up to in terms of the denominations, but the number of pieces of currency. And it could have been foreign currency. It didn't matter as long as it was real money. And they had one group counting the real money and one group counting paper. And then they had a person who would stand outside of that room and on purpose, but looking like it was an accident, drop files onto the floor. And they would have the people leaving the room individually, one after the other, but they would have a delay between when they could leave the room. And the people who left the room and had counted paper tended to be more sensitive, and when they saw this person drop the folders, they would stop and help. The people who counted currency didn't. They then had another test that they did, which was they had two containers of very cold, very, very ice cold water, same temperature for each. And they would have the people who counted currency stick one hand into the cold water, and they would have the people who counted paper stick their hand into the water. And the people who counted paper had currency had a higher tolerance of pain. They would keep their hands in the cold water longer than the people who counted paper. And they were instructed to keep their hands in the water for as long as they could. Something goes on in the brain that allows the people to have a higher tolerance of pain and keep their hands in longer in this ice cold water, causes people to be more self-absorbed and not stop and help the people while they drop their files. There's something biological relating to the, in the brain, in money and what it represents that causes people to do things. So if somebody is receiving child support in a case and it's more than what they need, it's still money, and getting them off of their position of this is money, I need this for whatever I need it for, security, whatever I need that money for. What is important is to understand what does money represent to the individual person, and what do they need it for? If they need it for their security, then we need to start delving into what are your expenses and what resources do you have available, because is all of this money necessary for your security? Because if we can look at everything that they have, not including that, and we know what their expenses are and estimated future expenses, if the money is important to them primarily because they're fearful for their future and the security it represents, then if we can demonstrate to them that they're otherwise secure, we may be able to get them off their position. It really depends on what the money represents to the particular person and why they think they need it. And you have to keep digging and digging and digging and digging, because you need to get to the core of what it is that they need it for. They'll say one thing, and as you dig further and further and further, you'll get a better understanding as far as why they really need it. And they may not have known. That's what mediation does.
Wow. That certainly gives me something to think about. So back to mediation then. I guess evaluative mediation isn't going to help you have those kinds of conversations. But would directive mediation help you with those kind of conversations? We got to wrap up, and then we got to have you back on because I've got 4 other questions I need to explore, and I can see that would take hours.
All right. Well, there's facilitative mediation where the mediator is setting up the environment and asking questions and helping the people come up with their own agreements. And we do evaluation stuff in facilitative mediation, but what we do is we're not evaluating what the law says in people's rights and obligations and positions. We're looking at various options that the participants come up with. And the participants may also include the mediator and their lawyers coming up with various options for solving a particular issue. And then we evaluate, but we're not evaluating, like I said, what's the law say is going to happen in court. We're evaluating what is the feasibility, are these options things each on one? Is this an option that husband and wife would consider? And then we're going through them and we're evaluating the feasibility, because while something may seem like a great option, it might just not be feasible. Wife might want to have the house, but maybe it's not feasible. Maybe she could get it, but she's going to be house poor, which we talked about when I was at the Detroit Expo. I talked about with Steve, that might be feasible in terms of she could do it, but she's going to end up with no social life and no money, and she's just going to be sitting in the house all the time because she has no more money left after she spends what it costs to maintain that house and pay the expenses. So we're evaluating the feasibility of things to come up with the option that the parents or the couple likes best and that's most feasible. And then they, and then they pick, that's the one they tend to pick because they were their options. And if it's the most feasible, then that's generally the one that they accept. That would be facilitative.
Right. And so that just goes to show you how much due diligence you have to go through when choosing your mediator too. I mean, I think people really have to think hard about the lawyer they're choosing. And the mediator is going to make a huge difference in terms of the outcome.
There was something in Australia about the need to regulate the mediators there, and it was talking about how the selection of the mediator is so important, and it does determine the outcome. And people seem to think that, you go and you hire a mediator and the result is going to be the same. The result is not going to be the same because it depends on what style of mediation that the mediator does, and it also depends on how the mediator facilitates and what their training is and what tools they bring to the table. And, the reality is if you're sitting at a table with one other person and somebody comes and sits down for 5 minutes, the energy at that table changes even if the third party doesn't say anything. And if that person then gets up and leaves and another person comes and sits down and doesn't say anything, the energy at that table changes. So the reality that people aren't factoring in is that there's a lot to the selection of a mediator, and some of it is just the energy that person's bringing to this mediation, just who they are and what the dynamics, how the dynamics change just by virtue of that person being there, let alone the technique, let alone the training and skills and other such things. The thing about the court-appointed mediators, at least we know that they have to have some, for them to be on the panel, you would hope that they have some level of training as mediators, but it's not necessarily so because a lot of these judges and courts and lawyers think that because they were practicing law that they're mediators, and they are, if we're defining mediation as evaluative. Judge Scott Gordon recently spoke. He's the new presiding judge. He's the new supervising judge for family law in Los Angeles County. He just spoke to a bunch of mediators and collaborative attorneys at a symposium that was given at Pepperdine Law School. And he's handpicked the top 25 litigators in Los Angeles County to be mediators. One of them happens to be Dennis Wasser. But the reality is that what is the training that these people have to be mediators? What we're talking about is, yes, they're the top 25 litigators, so they're more familiar with each individual judge because they're top 25 litigators. They're in court so much. And so they're familiar with the individual judges. They're very knowledgeable with the law. And so they're going to be able to tell the people, if you go in front of this particular judge on this particular issue, this is going to most likely be the result. So just call it a day and agree to this now. Yes, they're perfect for doing that if mediation should be evaluative. And he was speaking in front of a group of people who do not believe that mediation should be evaluative. So, when the court's picking these mediators, what style are they picking? I suspect they're picking mediators who are evaluative. So, I don't know what the qualifications for the panels are or anything, but if the courts in Michigan are anything like the courts here, then the judges only understand evaluative mediation.
So I guess it just goes to show, not everybody has the money. So that's the issue. If it's court appointed, it's more cost effective for them, but it's buyer beware, because what are you getting? Mark, you provide such incredible information, insight. I knew that this wouldn't be another just show on mediation. I knew we'd be all over the map. But if people want to get in touch with you and know more about your work, how do they contact you?
Well, they can go to my website, which is www.markbaeresq.com. That's MarkBaeresq.com. And it has my contact information as well as all of the articles that I've written and other such things.
You've written some really wonderful articles, and that would be a great start to doing your due diligence for anybody who's researching divorce, that and the Smart Divorce. And of course, all the DSR programs, the Divorce Source Radio programs.
You bet.
I completely agree.
Hey, if you'd like to write DSR, you can do that. Write us at divorcesourceradio@gmail.com. And Deborah, your contact information is still info@thesmartdivorce.com. And the
Absolutely.
website, thesmartdivorce.com. New website coming soon for Deborah.
Yeah, so look for it. And also like me on my Facebook page, trying to get those numbers up.
Doesn't that sound pathetic? Please like me. Everyone wants to be liked.
I know, I'm begging. But you know what? I've posted lots of great articles.
I've been trying to get more likes on my Facebook page too, my corporate. It's not so easy. It's much easier to get connections on LinkedIn than likes on Facebook.
Well, you know what? I found a service online that actually you pay them money and they bring you likes and followers and Twitters. I don't know how they do it.
So thank you so much, Mark. It's been a pleasure. We'll speak to you again.
Thank you, and thank you so much for inviting me back.
As always, I hope the program helped you. If you have a comment or question you'd like to ask us, we'd love to hear from you. You can leave us a voicemail on our listener line at area code 248-686-2256. Or drop us an email with your question or comment to divorcesourceradio@gmail.com. New programs are available every week on divorcesourceradio.com, as well as iTunes, BlackBerry, Stitcher, and all over the web. If you'd like to be notified when new programs are available, you can follow us on Twitter. Our follow word is Divorce Source. Also, if you're not listening from our website, I invite you to stop by divorcesourceradio.com, where you'll find a complete program archive. If you're looking for a specific subject, simply type it into our search engine, and chances are you'll find what you're looking for. We also have other resources available at our website as well. And while you're on our website, click on the Facebook icon and join the growing Divorce Source Radio Facebook community. Thanks for listening. Until next time, make it a great week and stay healthy. I'm Steve Peck.